Can you say yes or no for me?
Yes.
Thank you. And Ms. Robinson, the best you can, would you raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Will your client waive the formal reading of the motion?
Yes, Your Honor.
Ms. Robinson, in cause number 24, DCCR 1116, I have a motion to revoke your unadjudicated probation. This shows that you were placed on probation December 2nd of 2024 for aggravated assault with a deadly weapon, a second-degree felony, and that was a 10-year deferred probation. Is that correct?
Mm-hmm.
Can you say yes or no for me?
Yes.
Thank you. It alleges that you violated your probation. Count 1 says that you committed the new offense of criminal trespass, May 7th of 2026 in Jefferson County. And is that true or not true?
That's true.
Okay. Count 2 alleges that you failed to provide verification of performing the community service hours required. And is that true or not true?
True.
Count 3 alleges that you didn't enter and successfully complete the forensic program at Spindletop. Is that true or not true?
That's true.
Count 4 alleges that you didn't enter and successfully complete the anger management program. Is that true or
That's
not
true.
true? Count 5 alleges that you did not enter and successfully complete a parenting course as ordered. Is that true or not true?
That's true.
And then count 6 says that you're behind in your court assessed fees. Is that true or not true?
That's true.
Okay. Did you enter your pleas of true to all of those counts freely and voluntarily?
True.
And did you plead true because they're all actually true?
Yeah.
All right, then I'm going to find that you entered your pleas of true to counts 1 through 6 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. I'm going to reset your case for sentencing. We'll get an updated pre-sentence report and then we'll come back. Anything that you think is important for me to know, get that information to Ms. Holmes and she'll present it to me on your behalf when we come back.
Okay.
Okay, you can go back with the bailiff. Good morning. Are you Ariana Dorsey?
Yes, ma'am.
And Ms. Dorsey was previously in court, entered a plea of guilty to burglary of a habitation, first-degree felony. Have received the pre-sentence report. Have both of you had an opportunity to review that report?
I have, Judge. Yes, Your Honor, we have.
Any additions or corrections?
Nothing from not from the state judge.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 10 years. You're ordered to pay the $500 fine and follow all of the rules and conditions of probation, including entering and successfully completing the cognitive track of the ISF program. I also noticed in here that there was $450 in restitution that was requested. Did you
Yes.
have any other information about that?
Judge, I think that was just damage to the door and everything, when she came in, and we are asking that be added as payment of restitution.
I'm going to order that $450 in restitution as well. Ms. Dorsey, this is a great opportunity for you because you don't have a felony conviction on your record. This is a very serious offense. And so if you do everything you're supposed to, when you complete the probation successfully, the case will be dismissed. You'll never be a convicted felon. The other side of that, though, is extremely serious because if you violate any condition of probation, you can be brought back into court, found guilty, and sent to prison for between a minimum of 5 years up to 99 years of the rest of your life. Do you understand? ISF is meant to help you make better thinking decisions and things like that. So please take advantage of that program. Listen, learn, so that when you get out, you'll be successful. I'm handing you the trial court certification that shows this was an agreement that I followed, so you waived your right to appeal. All right, good luck to you, ma'am.
Thank you, Your Honor.
Thank you.
Hey.
All right, are you DeMarcus Elam?
Yes, ma'am.
And Mr. Elam is charged in cause number 26 DCCR 1221 with the first-degree felony offense of murder. And Mr. Reynolds was appointed to represent Mr. Elam. Ms. Holmes has stepped in while Mr. Reynolds is out for some time and has filed a motion asking that I reduce bond in Mr. Elam's case, which is currently set at 1.5 million. Is that correct?
Two.
Is it his is 2?
Yes.
Okay. And this is the co-defendant to the Mr. Blunt that I previously handled earlier today. All right, so let's just let me just ask the state with regard to what I did on the previous one. Is there any reason that this one should be treated any differently?
And judicial economy and all fairness, Judge, I think it would be appropriate to set both bonds at the same.
Okay, I will let you put some information on if you need or some evidence. I did grant the previous motion on Mr. Blunt's case and reduce the bond in that case to $1 million with the GPS and house arrest. I'm willing to do that based on the same information, unless you have something very different to point out about Mr. Elam, other than just he can't make the big bond.
Right, that's it. And just as far as where he would be staying, his mother resides in Humble. And that's the home that he would like to go to.
Which I wouldn't be opposed to at all,
Okay.
honestly. I mean, I think that would be better to have him maybe not as close to co-defendant and other things going on here. Would you have any issue if he's got a
That they
GPS?
Not be allowed to have contact with each other.
For sure.
Mhm.
So, I need to make sure in that other order on Mr. Blunt that I write in, on that order. No contact with, DeMarcus Elam. So what I'm gonna do then, Mr. Elam, is I'm gonna grant the motion. I'm going to reduce your bond to $1 million. Condition of that bond is you have absolutely no contact or communication with Mr. Blunt. I know you guys are incarcerated here together. I want to make sure their dates are on different dates in the future if they're still in custody, so that they're not back there together. Also, a condition of your bond will be that you will be on house arrest and have to wear a GPS monitoring device. You'll have to give that address. I'm not making it where it has to be in Jefferson County. So if you make that bond, you can go. I want it to be within Harris County or Jefferson County. You can't just go anywhere, but I will allow you to go live with your mom in Baytown, and you'd have to give that address to your bondsman.
Well, that could
Humble.
be
I'm
Montgomery
sorry.
County,
Is
not
it Montgomery?
It's still Harris County.
It is. Okay.
The court then turns to a first-degree murder case involving DeMarcus Elam. His attorney asks for a bond reduction, and the judge agrees to lower the amount from $2 million to $1 million. But this isn't an unrestricted release. GPS monitoring, house arrest, an approved residence, and a strict no-contact condition are placed on the bond.
Whatever county it is in Humble with your mom, I will approve. Okay. If for some reason she moves somewhere different, you're going to have to get with your attorney and get with the bondsman so that I know where you are. And because we're going to be watching that GPS if you make that bond. Okay. All right. You can go back with the bailiff. Okay. Good morning, sir.
Morning, ma'am.
Are you John Gray?
Yes, ma'am.
And this is cause number 25 DCCR 1396, Ms. Molfino.
Judge, we have extended an offer of deferred probation in this case, which the defendant has accepted. I wanted the court to know that I have been made aware yesterday, actually, of the fact that he is also being investigated by Harris County detectives for the same type of offense. This is an impersonation involving some labor law issues and posters, etc. He was here on bond originally. I think he tested positive, if I recall, and that's why he's been in custody. It was my position to offer that same probated term. I reached out to Detective Williamson yesterday. He agreed with that, but just wanted the court to know those things are in the works. If you see him in the PSI, and that would be the reason for the state's position to be that we oppose a bond, even though it's a deferred
Sure.
probation.
Okay. Thank you. And will your client waive the formal reading of the indictment?
He does, sure.
Mr. Gray, you're charged with the third-degree felony offense of impersonating a public servant from July 14th of 2025. And how do you plead to that charge?
That's good.
There's no, I guess, guilty. Either you did it or you didn't do it. Are you guilty or not guilty?
Guilty.
Are you pleading guilty freely and voluntarily?
Yeah.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? Do you fully understand them?
Yeah.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine and any other conditions that would be ordered, especially after a PSI, and I see any and all issues that are going on. Do you understand?
By the end of the hearing, the court has handled probation violations, felony pleas, bond conditions, and sentencing preparation. Some defendants receive another opportunity through deferred probation, while others face stricter consequences after admitting violations. The cases are not finished yet. Several will return to court after additional reports and sentencing proceedings.